Good morning. Welcome to the June 23rd, 2025 land use meeting in the South Walton Annex Boardroom. Welcome, everyone. We're happy to have you here and join us and appreciate your interest in the community. The commissioners, we have 4 commissioners today. Commissioner Drake is not with us today, so there will be 4. Let's stand, please, for the invocation and the pledge. Let us take a quiet moment together. Gracious God, thank you for this new day and for the chance to serve our community. We ask for your guidance as we do the work before us. Help us lead with wisdom, listen with open hearts, and treat one another with kindness and respect. Bless our county, its people, and all who work to make it a better place. May our decisions reflect fairness, compassion, and a true spirit of service. Keep us grounded in purpose and united in our shared hope for the good of all. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you and welcome again. Mr. Schoen, I think Mr. Tatum, we need Mr. Schoen.
I apologize. Good morning.
Good morning.
We have a relatively light agenda this morning with 1 continuance thus far. If the board would like to take that up front.
Yes, that'd be fine.
All right, we have a request to continue the Echelon project, number 3, under quasi-judicial items to the July 24th, 2025 BCC agenda.
So moved.
Motion to continue.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Thank you.
Madam Chair, what was the date on that?
The 24th of July.
Okay, thank you.
You're welcome.
Good.
All right.
Madam Chair, before we start, could you ask Mr. Radkisson to give a brief explanation of what a 2-2 vote means?
Okay.
In the context of a land use decision, the project is being heard. If the board cannot reach a decision on it, the status quo is maintained because no motion passes. In a 2-2, so a 2-2 deals solely with the motion, that means the motion is defeated under parliamentary procedure. It doesn't mean that the action is formally denied. It doesn't mean the action is formally passed, but there's no way to come back on a land use item where you have approval or denial and have a motion the alternative way. The presumption is it would too be a 2-2. So with that being the case, our approach in land use matters has always been that a 2-2 acts to preserve the status quo, which means the project does not move forward and is therefore denied in function, or a de facto denial is the way that is. So that is where we stand with any of the votes here today that end up 2-2, the project would be deemed denied and status quo preserved.
Is there anyone?
6-month prohibition against bringing it is not applicable, correct? They could bring it right back.
That under a 2-2, correct. If it is actually denied 3-2, they are at that point in time required to wait at least 6 months before resubmitting the application.
But if it's a 2-2?
If it's a 2-2, they do not have the 6-month wait because it was not a denial by the BCC.
Okay. Okay. Is there anyone you want to confer with before we move forward?
I just spoke with an agent for the item number 6, East Nursery Road
Commissioner
Subdivision.
Gladwell, if we can have your mic turned on, please. I'm sorry.
Sorry about that.
And they, in light of the current makeup of the board, they would request a continuance to the July 24th, 2025.
Okay, so that's the number 6, the East Nursery.
That's correct.
They want to continue until July 24th.
That's the request, yes, ma'am.
Okay.
Motion to approve.
Second.
We have a motion and a second. I know there are a lot of people here for that. There are a lot of people here for that. But we have a motion and a second on the floor, and I'm just going to take a vote. So all in favor say aye.
Aye.
Motion passes. It will be moved to July 24th. Thank you for being here, and we apologize, but we have to be fair.
It is,
Wow.
Is that the only one on Nursery Road today?
that's the only one on Nursery Road. You're welcome. All right, ready to
Wow.
proceed?
Okay.
All right, so item number one is the LRF Small Scale Future Land Use Map Amendment with rezoning. It is a request to adopt by ordinance. It is project number FLU 25-000025. It was reviewed by Ayanna Reed, and I will ask her to present it to the board.
Thank you.
Thank you, Stephen. Hi, my name is Ayanna Reed, REED, Planning and Development Services.
Good morning.
Good morning. So as Stephen mentioned, this is LRF, small-scale amendment with rezoning. This is a future land use with rezoning application submitted by Matthews and Matthews LLP on behalf of LRF Conservation Holdings LLC, requesting to change the future land use from residential to conservation or lesser category, and to change the zoning from residential preservation to conservation on a lesser district on 7.06 acres. The property is in District 5 and located on the south side of Bannerman Beach Lane, and is identified by the parcel number in your staff report. May I please enter the staff report into the record?
Yes, so entered.
Okay.
Thank you. So,
Motion to approve.
conservation, just to conserve this area.
Yes.
Wonderful. We have a motion to approve and a second. Any comments? Yes, ma'am. Good morning.
Good morning. Don Francesco, DONFRANCESCO. This is an absolutely beautiful beach, but my understanding is that the owners would receive a tax break on this, a tax break in the amount of about $75,000 a year, and this is owned by the neighborhood. So I want to ask a couple of questions. Is that why they are requesting this change in conservation, so that they can avoid taxes? There's also a chair vendor that sets up on that beach, and since they have purchased it, and there are chairs literally across that whole beach. You can't even walk in between them, and they're up there every single morning, and they're all day long, and almost no one is sitting in those chairs. So is the beach vendor gonna be allowed, when it's conservation, to set up those chairs and continue vending on that beach? That's the question. Also, what's the benefit to the public on this? We lose tax dollars. So is there a benefit to the public, or just to this neighborhood that has purchased this property? I also wonder, are we setting precedent? Are other neighborhoods or other beachfront homeowners gonna try and do the same thing? So again, another question to be answered. And does the owner have the right now to restrict, will they have the right to restrict us? I don't believe their property line, and it's a question to be asked. Does the property line go all the way down to the beach? And if it doesn't, which I don't believe it does, will the public be able to sit in the front of that beach outside of their property line? Or at least from the mean high water line down to the line? Right now, they're one of those beach accesses that has on-site the beach vendor, and anyone who's over there, people are immediately, the vendor is immediately going up, and it's not the best of interactions. So I just have some questions that I think you have to consider. It sounds good, I get it. Sounds great. I thought it was gonna be great. There's only one buildable lot, from my understanding, on that whole property. So it's not about that. It is about saving $75,000 a year and only their neighborhood being able to use that. And we really want to know, again, as the public, what benefit is it to us? And what will we be able to expect that we can do once this, if this is approved?
Thank you very much. I appreciate that. You brought up
Okay.
some things that I had not thought about, so
Okay.
thank you. I appreciate it.
Probably most of those are questions for the applicant, so it may be appropriate to let Mr. Tatum address those unless the board has questions for Ms. Reed.
Does anyone have questions for Ms. Reed? Well, Tatum is going to answer.
Before I defer to the applicant, I would like to also add to the record that the conservation easement and those details regarding the federal tax regulations is located in Exhibit D of your packet, if you want to refer to that as you're asking those questions of the applicant. From my understanding, it is, according to our maps, the parcel does extend to the mean water line. So that could be something that the applicant could elaborate on with you all today regarding what the intent is of the property as it aligns with the conservation easement in your packet. I'll defer to the applicant.
Thank you. Mr. Tatum?
Good morning, Commissioners. Just for the record, Stephen Tatum, on behalf of LRF Conservation Holdings. Let me start with the first question, why are we doing this? There's already a conservation easement on the entire property. The reason for the request for a change is because it's a residential preservation lot right now. And residential preservation lots cannot be split. By code, by the land development code, you cannot split them. So we're changing it to conservation, which is the most obvious fit since we're not planning on using it anyway, and then we can split it. The reason for the split is because LRF Conservation Holdings LLC is actually made up of members from Bannerman Homeowners Association and from the Little Redfish Homeowners Association. They came together and purchased this beach property from the developers of Bannerman. They want to split it. Basically where you see the outfall coming out in the picture that's up right now, that's the basic split line. I think it's a little bit off from that, but that's essentially what it is. Little Redfish will have one side, Bannerman will have the other. The properties do go to the mean high water line, so the public is obviously free to set up anywhere south of that, depending on where it's located that particular day and that particular hour. And not located, but where the water is. As far as taxes go, besides putting the conservation easement on it, there's really no tax benefit from this. There is the ability to build one house on it right now, so they were able to take advantage of that for offsetting for property tax purposes, for income tax purposes through the conservation easement, but that's the only tax benefit we'd be receiving from this. And that's an added benefit. That wasn't the reason for the purchase. There was no other rationale behind this other than, hey, we need to split this. What do we got to do to split it? And we were told, can't be RP, it's got to be something else. And we thought this would be the easiest route to get there. Honestly, I thought this was going to be the easiest decision y'all made all day.
Well, I thought so too until I heard the beach chair issue.
Let me address that. The beach chair issue is only on one side of the property right now. It's not,
Hey, ma'am.
anyway.
I can't hear when they
To my knowledge, it's only on one side of the property, and a lot of the pushback has been coming from the Preserve Homeowners Association because there are members over there who have an easement to get down into that area, but it's one of those easements that's, I don't know if it's 5 feet or 10 feet wide, but then it doesn't give any space on either side to set up. It's one of those old easements that,
To be clear, is that easement in favor of Walton County or in favor of a group of citizens or owners?
it's in favor of the preserve, and it's not even actually on our property. It runs beside our property.
So to be clear, while I am well aware of this issue, and we've looked at this piece of property many times in the county, that is not a county easement. I recognize this may be an issue for the neighbors, but that easement will exist and continue to exist regardless of what our zoning map says or what we call it. We cannot abolish their easement today, but we cannot also expand the scope of the easement just the same way we can't take it away by what we're doing today. So ultimately, if there's an issue with somebody who has an easement right vested to that beach, that is a civil dispute between the various holders of that easement and the person who owns the property in fee simple. Our decision, while it may result in a lot split and it may result in a change in title to a portion of the property, even that cannot do away with an easement. That easement runs with the land and would continue to travel with it, and Mr. Tatum's nodding for the record, so.
That's correct.
So as far as that goes, now, Mr. Tatum, I understand we have a variety of different surveys showing where, per the plat versus what's in the packet, where the mean high water line sits. I believe you would agree on behalf of the current property owner that to the extent that there is any sand below the mean high water line, which is where this property boundary stops, and I'm not asking you to commit that there is or is not, that at that point in time, the mean high water line, everything seaward of that would be public lands, correct?
Completely agree with that. That is the law.
And there's no ECL here, so we're not dealing with vending rights below that, and so vendors have no ability to set up and exclude the public's access seaward of the mean high water line. Now, if this is one of those critically eroded areas, and back to the east of the outfall, I believe it does jog even further landward for that mean high water line. It may well be that mean high water line's in the Gulf of Mexico right now. But to that extent, but please continue addressing the beach areas. I just wanted that on the record is that they cannot do anything seaward to the mean high water line. Now, if the mean high water line's in the Gulf, it may be a moot point.
Right,
Madam Chair?
yes.
Mr. Tatum, the thing on the screen now,
Yes, sir.
you want to split that into 2 lots. Okay, the smaller lot, what are you going to do with that?
It will stay completely vacant, sandy beach.
Okay, because I don't know what the law is, but as far as Tony's law is, you can't build on that piece of property.
That is correct. Cannot build that. There's, like I said, there's a conservation easement already which prohibits it. The only thing can be built is docks into the lake and/or doing walkovers. Those are the only things that it allows to be built. And that particular piece that you're talking about on the east side would be totally unbuildable anyway. Wouldn't be a lot of record at this point once we split it. It's going to be zoned conservation. It's got a conservation easement on it. There's no building on that parcel. Even, I think the dune goes almost all the way to the lake anyway.
Yeah, it does. It does look like that on the map.
Yes, sir.
Okay, all right. That's all I have, Madam Chair.
So, thank you. So it's my understanding that to split the lot, right now, the tax is $2,200 on that property,
That's the payable tax at
the
this
payable
point.
tax.
That's correct.
And to split it would probably increase that.
Potentially, yes. I honestly don't know how the property appraiser will look at it once it's got a conservation easement on it and zoned conservation as to what the valuation of it will be. So will it increase taxes or will they just keep them the same?
It will
can't
definitely
answer
create
that.
a separate parcel ID number for tax purposes.
It will
though.
do that, yes.
And then that falls under the property appraiser.
Is there any benefit to the community?
Only that we're preserving beach area. That is, I mean, yes, it's privately owned, but the area that is buildable will not be built on. So, you know, it's one dwelling unit going away.
So the only benefit is that one lot is not going to be built on?
I believe so, besides the fact that it's, you know, we're changing a residentially preservation zoned property into conservation and put a conservation easement, and that's in perpetuity.
Well, when I think of conservation, I think of something that is just, you know, appealing and easy, and there's not vending, and there's not all of this out there, that it's just conserved. So, you know, to see a bunch of beach chairs on there is really, kind of goes against the grain.
Well, conservation, well, first of all, let's talk about the beach vending. The beach vending that happens out there is for the property owners. They're not renting to the public.
Do they put up ghost chairs, or do they just have a managed beach program?
Well, they put out beach, I don't know if they put up so-called ghost chairs or not. But what I do know is that the area where they set up is on their privately owned property. They're not, so the public couldn't use that area anyway. They're not setting up south of the mean high water line, they're setting up north of the mean high water line. So the public doesn't have a right to be on that property anyway.
So, just so I'm clear, so would they or would they not be paying taxes on that beach property?
They would be paying some form of tax, yes, ma'am. Property tax. But like I said, there's no way for me to tell you a number.
Okay. Go ahead.
So there's no, excuse me, so there's no ECL in this area, correct?
No, sir.
Is it out in the water or nowhere?
There's never
Zero.
been a renourishment project which has established an ECL on this specific part of the beach.
All right, so it is what it is. There's nothing more public going to be used off of this other than below the mean high water line.
Unless the county conducts a renourishment or restoration project and ECL gets established in the future. Now, if that happens, but that's something we can't predict sitting here today.
So that is a possibility.
Absolutely.
All right, thank you.
Any other questions?
All right, thank you.
Thank you.
You sure there's nothing else?
Uh,
I'm really surprised that you're so
I'm a bit
hesitant. That's the reason I'm still up
confused
here.
When Donna came up, she had a lot of very interesting and valid questions. And again, my idea is something, conservation is something that would not include beach vending, but that's their private property. They're paying taxes on it.
I
We don't
will.
have any authority over that.
I will say this, and I'll ask Mr. Tatum to respond. Under our code, we're going to conservation or 2.02.29 of the Land Development Code. Now, this is a privately held land by which conservation easement exists, so therefore it's eligible to be moved into that category.
That's right.
Primary uses allowed indicate conservation uses, state forest or state parks and rec, and then accessory use allowed, uses limited to public access and residential and non-residential uses necessary to manage such conservation lands, e.g. ranger stations, research stations, and park amenities. Public access and residential uses, now I don't know that beach vending manages conservation lands or is necessary to manage it, but that would appear to be the limitations that now go into effect on this property. So I do think, and I think it's probably fair for the board to admonish you and your client that if this becomes an open vending season, that's something more than people setting up chairs for owners, that may well exceed the allowable uses in this category.
I can't disagree with you.
So there you go.
Okay.
So a pile of ghost chairs sitting there, to make clear about my point is, I think a pile of ghost chairs sitting there every single day is not consistent with the accessory uses allowed versus a vendor, and Mr. Schoen's nodding in the back, versus a beach vendor who goes and sets up a chair at an owner's request. Now, that doesn't mean that chair can't ever be vacant. We've talked about this many times, where
Right.
people get up and walk down the beach, go to the house for lunch, et cetera. So, I mean, I would just caution them that with this change, there may be complaints given from the neighbors if they believe that the beach vending activity exceeds that code has to respond to once this goes to
Understood.
conservation. Okay?
Okay. So you're going to let me know that they will not be putting ghost chairs on there. They will be set up for the individuals when they request them.
I will make sure the client understands that. I do not know if that is what they do now or not. I do know that they set up for the property owners. Now,
I don't think,
I can't right now.
Madam Chair,
Yes.
I don't think it's fair to ask Mr. Tatum that question because he's not gonna be out there every day and see what it is, but he will, if he says he will warn the owner of this, then that's what we need to.
And that's why I put it on the record, is this is notice to the owner, because he's their attorney, that they've been noticed. If they go out there and
And-
start doing it, they're going before a magistrate with this as part of the record.
And that's fair.
That's fair.
But the point is, people will know if they do, and they will send us emails, and we will know about it.
We
So
won't be happy.
we won't be happy. Yeah.
I'm
So-
very familiar with
Okay.
with that whole process, unfortunately.
Okay, thank you. Did we have a motion? We have a motion and a second. Yes, Donna?
Oh, she's already spoken.
Did, oh, no.
She's already
I-
spoke. She can't
I'm
come.
sorry, Donna, you've already spoken to this, and I'm not supposed to let you speak again. I apologize. We have a motion and a second on the floor. All in favor, say aye. Wait, public comment was closed. I'm sorry. Aye. So we have,
Excuse me, aye.
motion passes. Thank you very much.
Next items, Madam Chair, are quasi judicial for the ones that are left on our agenda. Anyone wishing to speak on the remaining items on today's land use agenda need to be sworn at this time. Please stand, raise your right hand, repeat after me.
Mr. Leary, yes, sir.
Oh,
Yes.
I apologize. I have those
Yes.
these backwards on my agenda, the way I have them in my packet. I apologize. I've done this to Mary twice.
I was going in my mind to the short term, so.
I thought I had a bad agenda, so.
Well, my next comments about why I have those reordered are probably gonna make more sense, so let's hold for about 3 minutes, and I'll make a comment. Stephen, if you would, please.
All right, thank you. Yes, item number 2 is the short-term vacation rental land development code text amendments. This is a request to approve by ordinance. Walton County Planning and Development Services staff is proposing substantive text amendments to chapters 1, 2, 5, and 9 of the Walton County Land Development Code. The proposed amendments relate to code compliance issues, recent statutory changes, and continuing staff efforts to maintain and improve the interpretation and implementation of the LDC. These changes will impact many current standards and components of the code, including but not limited to access management, conditional use review, planned unit development review, registration submittal requirements, et cetera. Josh Allen, our short-term vacation rental coordinator, has worked really hard on these amendments, and I'll allow him to present and answer any questions for you after Mr. Atkinson has his time, I'm sure.
Thank you.
Well, you got a commissioner first, and then I have a comment.
And I
Or
had a question for you.
Go ahead. Okay, go ahead and ask your question.
How, if the governor signs, Bill 180, how is that going to affect, I mean, are we doing something that's gonna be overturned in 2 weeks? Or-
Well, that was gonna be my question. Mr. Shawn, if you would, please, just I want to put 2 things on the record before it is first reading, so there's no problem if y'all want to hear it today and move it forward. Understanding you may not be able to adopt it in 2 weeks, but Mr. Shawn, in your reading of this, is it fair to say that with the additional, and I think it says right there in front of us, of course, that there would be many changes to current standards and components, that some of those may be deemed more restrictive elements of our land development regulations?
I think there may be an understanding, someone could find that with some of these changes, yes.
So let me ask you this, and I agree, I think that's an arguable point, and I'm fine arguing with that if the board wants me to. It is the third category I'm concerned under Senate 180. It says a more restrictive or burdensome procedure concerning review, approval, or issuance of a site plan, development permit, or development order. If we're going through a different review process, would you agree there is more conditions to be satisfied as part of the conditional use review, plan unit development review under the code at this time?
I think that's probably accurate. There's an additional level of review with some of these things. I don't know if I would consider it more burdensome, but again, the argument could potentially be made.
So understand, Senate Bill 180 was signed by the officers of the Florida House and Senate on the 18th of this month. It was transmitted to the governor. The governor has not reviewed it. I've spoken to our lobbying team, as well as the lobbying teams associated with the Association of Counties and the League of Cities. It is well expected the governor executes and signs Senate Bill 180 into law. The problem with Senate Bill 180, while it is a hurricane relief bill, and people, I've had this question many times, how does this matter? We are an impacted local government based on the executive orders issued last year, and this bill has retroactive application to August 1 of 2024. So just passing something and getting it adopted before the bill goes in is not saved. And what I read to you there is one of the restrictions. It says we may not propose or adopt. Now, if the board wants to roll the dice and go from first reading to second reading, understanding that if that bill passes, we're just going to kill it at second reading immediately, I'm not going to argue with you. We can go through the process today. But the word that worries me is may not propose. We are proposing a bill that proposing an ordinance that on its face is presumptively invalid under this, and the penalties for doing so are staunch. So the safest course of action today is to table this until whatever your choosing is, certainly into the month of July, to allow us to determine if the governor signs it or not. But I can tell you this, if this was an adoption hearing, I'd be saying you can't afford to do this because of the penalties.
Madam Chair?
Yes.
I make a motion, we table this.
Second.
We have a motion and a second to table this. I would just like to add a few things. First of all, I'm not pleased with the rewrite of this. I don't think that, I don't think it's clear. I think it's kind of muddy, and I think that there's some others out there that have done some very user-friendly documents, and I think we need to be more user-friendly in keeping it simple with it and relaying the message that we need to relay. There are a few things that I don't believe have been added in here that I would like to see added in here. One of them is the square footage as far as, and this may be a no player whatsoever after this bill, but right now, the way it's written is one person per 150 square feet of the gross floor, and it seems to me like, why would we do, that's why we have so many people in these short-term rentals, because we're going by the size of the house. They don't sleep in the bathroom, they don't sleep in the kitchen, they don't sleep in the closet. Has to be 70 square feet, you know? So-
Sorry to interrupt, but I've been in one of those. Yes, they do. And guess who was stuck in the closet?
Well, it's supposed to be a minimum of 70 square feet with ventilation.
Yeah.
To be considered.
And it had neither of those. It wasn't here, Madam Chair. It was in Orange
But-
Beach.
I think that what we need to do is we need to have it 150 square feet per bedroom, you know, with total amount of the bedroom rather than the entire house, and bring it down from, instead of a house, you know, housing 36 people like they do on Walton Way, bring it down to something that's more reasonable. This is just way out of control, and that's one way for us to kind of, you know, it would eliminate some of the noise, some of the trash, some of the parking problems and all of that, and it's much more realistic. And so that's one thing I really would like for you all to look at.
I'm
Now-
afraid it's gonna be a moot point because the governor's gonna sign that bill. I mean, it's,
Well, he's
oh, yeah.
coming, what, tomorrow? Is that the purpose for his coming
No.
tomorrow?
That
No?
is,
Okay, okay.
This one's bigger than us. It just so happens to catch all 67 counties and effectively every municipality in the state. This was not a Walton County-specific piece of legislation. It just so happens, based on the number of storms and the radiuses and the declarations under the executive orders or states of emergency, when you read them, literally capture all 67 counties.
Okay, well, we have a motion and a second to table this. Any comments from the audience? Yes, ma'am.
Eileen O'Sullivan, 259 Barton's Way, Santa Rosa Beach. Do you need me to spell my name? Okay. Hey, question. So this bill, this SB 180, does that mean it's going to cancel out the short-term certification process or not? Because
No.
I am for the short-term certification process.
No.
So certification of short-term rentals, registration of it, no, that's not part of it. In terms of any land development regulations that have been amended or adjusted since August 1 of last year that are related to it, could well be deemed canceled. But the registration element itself is a registration under a business use,
Okay.
even though it's under our LDC. At this point, we do not anticipate that the entire short-term rental ordinance, based on when it was originally adopted and its scope, would be affected by
Okay.
this. That's not our anticipation, at
No,
least.
that's fine. So back to when this all started, in 22, Josh, right?
We're just
21.
talking about tabling this.
No, I know, but I'm just trying to figure out this because people have paid for a few years now.
We don't know what the governor's going to do. So
Okay.
we are tabling this right now so that we don't try to do things that are going to be null and void anyway.
I gotcha.
So once we bring it back, then it would be more relevant.
All right.
Okay.
So wait for next month.
Yes.
Okay, thanks.
Thank
Donna.
you. Appreciate it. Okay, all in favor, say aye.
Aye.
Okay, motion passes and it is tabled.
now we go to quasi.
Now we're ready for quasi, Mr. Shawn?
Yes, sir.
Now you see why I had all my notes queued up on the wrong item this whole time. Anyone wishing to speak on the remaining items needs to be sworn. Please stand, raise your right hand, and repeat after me. I do hereby swear or affirm
I do hereby swear or affirm
that the testimony I present
that the testimony I present
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Madam Chair, staff, and one applicant in the audience has been sworn.
Okay, thank you.
Okay, item number 4, Stephen Schoen, SCHOEN with the Planning Department. I have been sworn.
Madam Chair, may I interrupt just a second
Yes,
and ask Mr. Smith a question?
certainly.
Mr. Smith, were you here when we first started today's meeting?
Yes, sir, I was.
You heard Mr. Adkisson's opinion on 2-2 votes?
Yes, sir. I did.
Okay. I didn't see you back there, and I just wanted to make sure you
Yes, sir.
heard.
Thank you.
Thank you,
Thank you, Madam Chair.
thank you.
Okay, so this is the Hawks Landing Phase 2 replat. This is a minor replat. It was requested to approve by final plat. It's project number PLA 25-000058. It was reviewed by Robert Baranti, who is not here with us today. This is a plat application consistent with previously approved DO MAJ 20-000023 and has been submitted by Interlight Engineering Corporation on behalf of Hawks Landing Development LLC. They're requesting to replat Phase 2 of Hawks Landing on 8.91 plus or minus acres. The project site has a future land use of mixed use and a zoning district of village mixed use. The property is in District 5 and identified by the parcel ID in your staff report. If I could please enter the report into the record.
So entered.
Thank you. And I just want to briefly touch on just the fees and those sort of things. So this was obviously previously approved through development order as well as plat. So this is a minor replat. And I'll let the applicant speak to the substance of that replat. But I say all that to say that all the fees have been paid. They were paid previously through the original plat. This was a PFS project. There are no outstanding fees. All the review fees have been paid.
Okay, I believe that there's $42,986.66 plat fee, or not plat fee, but the proportionate fair share, or I guess mobility fee now. Is that still required?
No, so this wouldn't be under the mobility fee system. It was approved way before.
So it would be under the prop fair
It would be
system?
under the prop fair share.
So did they pay the 42,000 plus?
Absolutely. Yeah,
Okay.
everything has been paid prior to this application being
Do we
submitted.
have copies of the receipts?
No, we do not have copies of the receipts. I can certainly attain those. Based on the nature of the replat application, I was hopeful it wouldn't be an issue, but I can absolutely get them for you right now.
Okay, thank you very much.
Yep.
But go ahead and continue. You can continue, Stephen.
Oh,
I was
done with my presentation. I was going to turn it over.
Oh,
Unless you have
okay,
any other
okay.
questions for me, I'll get those receipts pulled up.
Thank you.
Thank you, Stephen, and good morning. I'm David Smith with Interlight Engineering, and this replat is a very, very minor request. We are not changing any density. It's simply the end of the townhome units, the lot lines are being extended 1 foot so that the material, like the exterior part of the material, will be within the lot line. So 1 foot on either end, and then in the back, it's being extended so the patio falls within the lot. And this is consistent with the development order addendum, and it's also consistent with Phase 1, the way that Phase 1 is currently platted. So it's a very minor request. We're not moving lots or changing lots. We're just extending that lot line by 1 foot on either end, so the material's inside the lot line, and then in the rear, so the patio falls within the lot as well.
But that patio is 6 feet wide, correct?
Yes, ma'am.
Okay, so, and you say that's not going to have any effect on the stormwater?
Well, the patio was already incorporated in the stormwater management facilities. It's just so that the patio itself falls within the lot, which is owned by the lot owner and will not be in the association property.
Will they still have the proper setbacks?
Yes, yeah, they're townhomes, they will.
Okay, okay.
Motion to approve.
Second.
We have a motion to approve in a second, but I still have questions.
Yes, ma'am. I'm more than happy
Okay.
to answer any questions.
Did you, or did the developer exchange 5% of the land in exchange for the rec plat fees?
I'm not the engineer. We are the.
Stephen is saying
Okay.
yes. Okay,
So-
Stephen, can you speak to that for a moment, please?
Yes, as part of the original approval, the dedication of land was approved with the development order. It is, if you're looking at the plat map, you'll see it's actually kind of hard to tell based on the coloration of
Can
of
you
the
go back
site
to
here.
the other one, please? Jason, thank you.
Okay, so if you see here, there's, under the conservation residential portion of the site, the green portion above the VMU, you'll see about a 2-acre chunk, just that parcel there by itself. That is the dedicated portion of the site, right below the 4 single-family lots.
Is it wetlands or
There is a portion that is wetlands, yes.
how much?
It looks to probably be, probably 3/4, give or take, maybe half.
Why are we exchanging that in lieu of the plat fees? That's not usable.
Well, at the time of the original approval, there was not a lot of consideration given to the nature of the land being dedicated. It was just, you dedicate or not.
Well, the original approval, if I'm not mistaken, the DO was issued January 19th of 2024, correct?
There was, no, that does not sound correct to me.
That's the information that I typed up in my review of this. And my question was it extended or was the project being worked on? Because if it's not worked on within a year, then they have to go back to the drawing board.
This project has been in some form of construction since the approval. Most of it's already built out.
Okay. Okay.
Where are you seeing that date?
I went through the whole thing and I typed it up on a sheet, so I don't know exactly where that reference is. It's somewhere in the documents that you all provided.
Okay, so the original approval occurred on January 19th of 2021. That was when
Oh, original
major-
approved, BCC approved December of 2020.
of 20, yeah,
Okay.
that's correct. Yes, ma'am.
So I think that's my question is, if it's gone back that far, as long as they've been doing something, then it's
Yes.
okay. But if they don't, then they've got to go back to the drawing board.
No, they've been moving through the process again. I believe Phase 1 is almost entirely built out, if not. There are folks living in many of the units already.
Okay, okay.
And it looks like the DO was issued January 19th of 2021. It's in the staff report on page 2 of 8.
Okay, okay. Also, the 911 fee of $1,000, I need the receipt on that. And this 5% exchange for the rec fees, is that currently in our land development code that is a developer's decision, or is it the county's decision?
So the code doesn't provide a decision-making body there. It reads that it's the decision of the developer. It doesn't say as approved by the board or any
We need
language
to
like
change that.
I understand that, yes, ma'am.
Okay.
And for the record, it's in the comprehensive plan policy R-2.1.9. And it says that the developer is required to dedicate a minimum 5% of the gross area. And then later it says alternatively, the developer shall pay cash in the amount. So it doesn't dictate that. That is something we'll absolutely talk about at the end of today's meeting.
So it doesn't dictate anything about they want to give us 3/4 of the acreage in wetlands?
That's absolutely correct.
That's very unfortunate on our part.
It appears, and Mr. Shawn may know more about this than I will. It predates me by many years at this point, and I think it may even predate Mr. Shawn's time with the department. It appears that somewhere between 2011 and 2018, the provisions of the Land Development Code that directly spoke to these issues were amended out, and the remainder of that is the comprehensive plan, which is the policy that's been used. We do have the Greenway Preservation, Greenway Corridor standards that do fall within the LDC still and talk about it. But in terms of the actual provisions of the code that spelled out a lot more about how this would work, those were all removed, and therefore the only thing we were left with was the comprehensive plan language that has now continued to be in effect since that time. So we're about 14 years in to that change, from what I can tell.
Was that board approval, do you know?
Oh, yes, ma'am. It had to be an ordinance amending the land development code. And from what I will, Stephen may have more information on this than me. It appears there was some discussion at the time about coming back with a revised rec plat fee process. And that discussion occurred, but it predates everybody on this board by at least 5 or 6 years from what I can tell. And I can find no record of where it ever came back. Now, it may have, but I can tell you it was never adopted.
Well,
That's the part I
There
can
are
tell.
several things in the Land Development Code that should have been done a few years ago that never came back, and that's what I'm going to be talking about this afternoon. Not a reflection on you, Stephen, at all. I just, there are just a lot of things that were not done that should have been done. And so, and I am very strongly ask that we change that comp plan or include it in our Land Development Code, that it is a county decision, not a developer's decision, because we're being given this little sliver of land in exchange for plat fees, which is supposed to be a benefit to the community, to the citizens, for them to be able to use for recreation. You can't recreate in wetlands. So it's just wrong.
I won't step on Mr. Schoen's toes, and I don't really want to step on Mr. Smith's toes, who's waiting patiently on a project this doesn't apply to. But, and we will talk about it later. We're in need, and Mr. Schoen and I have discussed this, and he's working with his team to get us an updated study on that. I believe he and I are in accord that what we're hoping to ask for in that study, that the board would then have an opportunity to approve, is a recreational plat fee that then has, as an alternative to the fee, the opportunity to donate recreational lands in the discretion of the county to the extent that we're allowed to have that discretion under the Florida Impact Fee Act. We have some, we don't have a ton, but the idea would be if we make this a fee-based determination that is based on a studied amount, that's what gets you to that point. But where we are now is we do need a study that updates what that actual fee is,
But you
because we are
just-
very far back.
You just said the recreational area, right?
Well, an area of recreation.
An
You would have to be
area
able,
of recreation.
Yes.
How do you recreate on wetlands?
you wouldn't be able to, and the idea would be if this was coming up today, we wouldn't recommend you
Madam
accept it.
Chair, this is not appropriate. We're here to talk about his project. This is way out of
Well, in
bounds.
his project, they're
But
giving
that
the
was done
county.
5, 7, 8 years ago. We couldn't undo it if we wanted to. We
Well-
need to get on with Mr. Smith's project.
Well, we will
That's
get
what
on
we're
with
here
Mr.
for.
Smith's project, but I wanted to find out some information on
But this
this.
is not the appropriate time.
Well, to me, it's the appropriate time. Mr. Smith, would you like to come back up? Anything else that you want to say about this development?
Like I said, it's consistent with the approved development order addendum. We're not changing any, or adding lots, moving lots. It's simply just to extend the end units 1 foot for the material, so it'll be in the lot. And then the back rear lot line, 6 feet, so the patio, which is already accounted for in the stormwater design, will be within the lot and owned by the owner, not by the association.
Okay, and we have a motion and a second. Go ahead.
So, I tend to agree that we can't hold up something for something that was done previously, but I do find it interesting that we're given plat fees for swampland, wetlands, whatever you want to call it. Have you found the receipts for the 40,000?
And this should have been done at the time of the original plat, just to be clear.
They're not
even
even
any
any fees.
Yeah, this is a replat. This wouldn't technically vest in him.
I'm done.
Okay, we have a motion and a second. I don't think there's anyone in the audience that wants to speak to this.
Madam Chair, I
So-
will say for the record, since you asked, in case this comes back up, page 5 of 8, last revision, June 9, 2025 of your staff report, page 8 of 37 of the total agenda item, sidewalk fee buyout. No sidewalk fee buyout was requested by this project. 2, preservation buyout fee, no preservation required for this project. 3, prop fair share fee. PFS was paid with the plat. 4, plat recording fee due at time of recording of the replat. That is true. That will be when it's recorded. 911 recording fee, no new lots created by this replat. While it doesn't say it, I'll put it on the record. That would mean there is no new 911 address, therefore we can't collect that fee. And then it says rec fee, 5% of the plan was dedicated with the plat. So Not saying any of that's wrong, but I just want to be clear, since the questions were asked, it is in the staff report that those issues were already addressed, or that we have something in our record that the board is hearing today that says all that.
Okay, wonderful.
Just to add to that, the PFS was paid on April 11th of '23 in the amount of $42,985.66 under receipt number 1592. And
Can you tell me that date again, please?
April 11, 2023.
Okay. Thank you.
And the 911 fee was paid the same day, receipt number 1591.
1591, okay. So they did pay 911.
On the original plat, for
Okay.
every 911 address created, they wouldn't have paid a 911 fee on the replat because there's no
Right.
new 911
Right,
address being.
okay, okay. Thank you very much for that, I appreciate it.
You're
Thank you. Okay, we have a motion and a second on the floor. All in favor, say aye.
Aye.
Motion passes. Thank you. Thank you very much. Sorry you had to sit through my questioning there.
No problem. Thank you. Have a good
Thank
day.
you.
Okay, item number 5 is the Grand Inlet at the Park Plat. This is a request to approve by final plat as project number PLA 24-004048. It was reviewed by, excuse me, Rosanna Edwards, and I'll ask her to present.
Thank you.
Thank you.
Good morning.
This is the Grand Inlet at the Park Plat. It's project number PLA 24-000048. It's a plat application consistent with the previously approved development order MIN 23-000012 and submitted by GeoPoint Surveying on behalf of Scenic Highway Partners LLC. They're requesting to plat 3 single-family lots and associated infrastructure on .9 plus or minus acres. Project site has a future land use of residential and a zoning district of neighborhood infill. Project's in District 5, and it's located at 220 East Park Place Avenue in Inlet Beach, and identified by the parcel number in your staff report. If you would please enter that into the record.
So entered.
This project was unanimously approved at TRC January 7th of 2024. It is consistent with the development order approved November 14th, 2023. The Mylar has been signed. All fees have been paid. I also provided you a receipt this morning, which included the 911 fees and the recreation plat
Thank
fees
you.
for that
Thank you.
project.
Appreciate that.
There was no, this fell under the prop fair share, so it met concurrency at that time, so there will be no mobility fees collected. The other fees, there was no sidewalk buyout or preservation buyout. And like I said, the plat recreation fee of $144,936 was paid May 12th of this year.
Thank you very much for providing that document. I appreciate that. That's
You're
great.
welcome. If you have any questions, I'll answer those.
Motion to approve.
Second.
We have a motion and a second. Any comments from the board? All in favor, say aye.
Aye.
Motion passes. Thank you very much.